Hello viewers, how are you all today? Moving forward with the topic of negligence, today we will discuss the theories and kinds of negligence. Now let's take an example. A car approaches from around a corner, blasts through a stop sign and rushes into an intersection, just missing any onlooker on foot and in another vehicles. Thankfully, no innocent bystanders were harmed, but events like these far too frequently result in severe harm, if not death. It's common for people to use the word negligent to characterize the acts of the driver in the previous paragraph. But what does this word actually mean in the legal sense? As we have already discussed, that negligence is a civil tort that happens when someone violates the duty of care they owe to their neighbors. Here, neighbors refer to anyone who can be harmed by their activity. And as a result, the other person suffers some sort of legal injury. In simple English, negligence is defined as a person's carelessness that leads to an injury or other harm to another person. It's crucial to remember that the harm must be legitimate. Let's now talk about the various theories of negligence. Whether negligence is a state of mind or a pattern of behavior is up for debate. The two theories of negligence are subjective and objective theory. Let's discuss the first one, that is the subjective theory of negligence. According to Austin, the absence of awareness, which one's responsibility would logically reveal, is the fundamental or radical concept in the theory of negligence. The result of carelessness or failing to analyze the nature and consequences of one's wrongdoing is negligence. In this view, negligent behavior is the exact opposite of deliberate conduct. Austin's hypothesis that carelessness could be either purposeful or unintentional has drawn criticism. One may cause harm without necessarily intending to. For example, by being negligent about the consequences of a risky behavior or by holding the mistaken idea that unfavorable events will not happen. This is a case of inadvertent negligence. Austin was referring to the most typical case of neglect. There is another kind of neglect, though, in which there is neither negligence nor error. Although a person may be fully aware of the risks involved and the danger others are exposed to if they drive a car too fast on a busy roadway, they may only be found guilty of negligent homicide rather than murder if someone is injured as a result. Salmon characterized neglect as having an excessive lack of concern for one's conduct and outcomes. A careless individual is one who shows no concern. Neglect essentially means showing a lack of interest, even if it is not the same as being careless or mistaken. Salmon contends that carelessness rather than inadvertence, which may or may not be the result of carelessness, is the fundamental component of negligence. Sometimes intentional and thoughtless activities can be disguised. A deliberate action is one for which the performer intends and anticipates the outcome. The deliberate avoidance of doing something is referred to as forbearance. For this reason, forbearance is a terrible deed done on purpose. On the other hand, omission describes not doing something after giving it careful consideration. Therefore, whereas omission results from negligence, forbearance is also the outcome of intention. Omission is an unintentionally bad action. If negligence or a lack of intention are both mental states, then intention must also be a mental state. The advantage of the subjective perspective is that in some situations, figuring out whether a man was negligent will depend in part of his mental state. In terms of criminal law, there is a clear distinction between intentionally causing harm to someone and doing so negligently. One must consider the accused knowledge, objectives, goals, and other aspects while assessing whether he or she is guilty of either offense. When there appears to be obvious neglect, examine the party's mental state may show instance of malice. A trap door may be left open so that your opponent can go through it and die as a result. Poison can be left unlabeled with the goal that someone will swallow it by accident. A ship captain has the potential to purposefully capsize his ship by floating the accepted norms of good seamanship. A father who neglects the administer medicine to his ill child may also be guilty of intentional homicide. In none of these circumstances can be distinguished between intentional and negligent wrongdoing without penetrating the offender's mind and gaining insight into his subjective perception of the act and its consequences. From the outside and objectively, it is impossible to discern between the two types of infractions. The advantage of the subjective method is that it makes the distinction between negligence and intention crystal clear. The evildoer wants undesirable outcomes. The negligent offender is not concerned with the consequences. In contrast to the deliberate wrongdoer, who is liable because he intends to cause harm, the negligent offender may be held accountable because he did not do enough to prevent the injury. Now let's see the other theory, that is the objective theory of negligence. Some legal professionals argue that negligence is a particular pattern of activity rather than a state of mind. This point of view contends that negligence is the failure to use reasonable caution. According to Clark and Lindsell, negligence is the inability to apply the due diligence that is legally expected of one in a particular situation. According to Pollock, negligence is the polar opposite of diligence, and diligence is never described as a mental disorder. According to the objective approach, negligence is an objective rather than a subjective fact. It is more of a certain action than a particular mentality or kind of behavior. Negligence is a violation of the duty to exercise care. To take care is to safeguard oneself from the unfavorable effects of one's actions. The act of acting in a way that a prudent, reasonable person would not is known as negligence. Driving at night without lights is careless, since lights are a symbol of intelligence. Because of this, taking care is no longer a mindset or attitude. The majority of the evidence for this viewpoint comes from the tort law, where it is well established that the negligence refers to failing to act objectively in a way that a reasonable man would expect. Salmon, a noted jurist, criticized the objective theory on the following grounds. Analysis that was not done thoroughly led to the comprehensive identification of negligence with carelessness. Second, negligence need not always be the cause of a failure to exercise caution. A failure to take measures could be unintentional or intentional. Third, it is impossible to determine whether a man's lack of care is negligent, purposeful, or accidental by simply observing his behavior. And fourth, the only way to pinpoint the negligent act is to examine the man's mental attitude, which gave rise to the in-issue conduct. Now let's talk about reconciliation of the theory of negligence. Glanville Williams attempts to unite the two hypotheses by claiming that the word negligence has two meanings and that each of the two concepts symbolizes one of them. On the one hand, negligence can be contrasted with intentional activity and inevitable accidents. Unlike purpose, negligence is a term that is subjective, which is a state of mind. Poison can be left unlabeled with the intention that someone will ingest it and die. It is challenging to tell whether the behavior was careless or purposeful in this case unless we gave glimpse into the offender's mind. It's possible that the toxin was left there unintentionally. Neglect, as opposed to an inevitable accident, is a certain type of behavior. The only way to determine whether the defendant caused the injury intentionally or accidentally is to look at whether his actions met the standard of a reasonable man. Therefore, it may be claimed that there is no intrinsic tension between the subjective and objective theory because they apply to various factual settings. Now let's talk about the different types of negligence. Depending on the context, ignorance can take many different forms. Additionally, each state has different rules defining carelessness and the level of accountability that each type of negligence entails. However, the list of careless actions below is normal. Let's discuss the first one, that is the criminal negligence. Criminal negligence is defined as conduct that differs materially from what a prudent person would do in the same or similar situations, because the actions may not be seen as considerably departing from what a reasonable person would have done. Civil negligence differs from criminal negligence. Now before discussing civil negligence, see a bit of examples of criminal negligence. The first is, because texting while driving is illegal in this country, it is criminal negligence for someone to break into someone else's automobile while they are driving and texting at the same time. Second, similarly, it may be considered criminal negligence when a person is operating a motor vehicle while under the influence of alcohol and kills a pedestrian. Third, if a nursing home nurse neglects to feed a patient and the patient dies as a result, the nurse may be held criminally accountable because the patient was put in danger of death as a result of nurse's criminal negligence. Fourth, it is possible to charge a hospital staff member with criminal negligence if they provide a fatal dose of medication while they are not paying attention. Fifth, it may be deemed criminal negligence if a person who is supposed to be a nursery's carer fails to provide care in exchange of another person's child. Sixth, it could be deemed criminal negligence for a doctor to administer an additional medicine to a patient who already has an allergy to it. Seventh, a doctor is guilty of criminal negligence if, in exchange of payment for the services he provided, he replaced a patient's lungs during surgery or left any tool or dangerous substance within the body of the patient. Let's take one more example, that a parent may be charged with criminal negligence if they leave their 2-year-old at home while they go out to a bar. This is due to the fact that it is violation of their duty of care, putting the child in grave danger. Now let's discuss civil negligence. Civil negligence occurs when a person fails to exercise ordinary care or due diligence, but criminal negligence relates to the conduct that is considered so extreme and rash that it is a clear divergence from the way an ordinary prudent person would act and is considered to be more than just a mistake in judgment or distraction. Now let's see some examples of civil negligence as well. A store that sells mid-season without any protection may be acting recklessly. This store is well known for its beer and it typically has a lot of visitors inside. Second, a pharmaceutical corporation may be deemed negligent if it releases a medicine without first testing it on humans. Third, driving through a stop sign while exceeding the posted speed limit may be construed as negligence. When a dog is let loose in the courtyard, of another person and he ends up destroying their garden, it's possible to label the person as careless. Negligence may be applied to an office where mopping is being done but the floor shows no signs of being wet. A business that is not organized in accordance with SEBI regulations may be deemed careless. A physician operating on the incorrect patient may be deemed negligent as well. So then the question arises that how is criminal negligence different from civil negligence? In criminal negligence cases, the plaintiff only needs to establish that it is highly likely that the defendant was careless. Hence, the burden of proof is lower. However, the plaintiff must prove the defendant's negligence in criminal negligence proceeding beyond a reasonable doubt, which is strictest level of proof. According to this condition, the evidence must be so strong that the defendant's criminal carelessness is the only plausible explanation. In a civil negligence case, the at-fault party's penalty is limited to the harm done to the plaintiff or compensation for damages. Convictions for criminal negligence result in significantly heavier punishments such as prison term, a fine, and probationary supervision. For instance, a 2-year prison sentence, a fine, or both may be imposed under Section 304A of the IPC as punishment for criminal negligence that results in death. For instance, if a person murdered someone while operating a vehicle while under the influence of alcohol or drugs, it would be considered criminal negligence. This would be considered quite reckless behavior. However, if a cleaner at a workplace washes the floor and forgets to leave a signboard that reads wet floor, any accident that occurs would be considered civil negligence because the housekeeper only exhibited a small amount of severe carelessness. Let's see the next type of negligence, that is comparative negligence. Comparative negligence is one of the most prevalent acts of omission and commission that entail some level of legal responsibility. Take into account, for instance, the likelihood that the victim contributed to some of their losses or injuries. They are compelled to provide a specific partial payment to cover a fraction of the damages in such case. The amount awarded to the plaintiff is lessened as a result of the fact that personal injury damages are diminished by the percentage of overall cost of the plaintiff's negligence. If the plaintiff receives $10,000 in damages from an auto accident, the jury will meet to determine whether the plaintiff was at fault. The total amount of damages would be $7,000 only if it were found that the plaintiff was 30% at fault. Comparative negligence divides the total amount of damages or injuries between the plaintiff and the defendant in accordance with the level of liability that was specified. Moving on to our next type of negligence, that is contributory negligence. A behavior that contributed to someone's injuries or damages is referred to as contributory negligence from a legal standpoint. Such actions fall short of the prudent standard that people ought to follow for their protection. Most of the time, the defense team can use contributory negligence as an argument against the allegation of negligence. However, more states are turning away from this strategy over time. A contributory negligence viewpoint typically works against the plaintiff. Now let's talk about the convergence of comparative and contributory negligence. Combining comparative and contributory negligence is another frequent form of negligence. This modified view of negligence frequently incorporates the two convergent forms of negligence. When a jury evaluates carelessness from this angle, the plaintiff may be eligible to receive up to 50% of the losses or damages sustained. For instance, someone might have been texting while operating a vehicle. This action and another speeding car may have contributed to the ensuing accident. In these situations, the jury will weigh both forms of negligence before deciding how much liability there is. In certain situations, the jury decision includes modified comparative negligence. The extent of harm or damage that the plaintiff and the defendants both experience is how this convergence is to be interpreted. Let's discuss the next negligence, that is gross negligence. A person engages in gross carelessness when they completely disregard the safety of people around them. However, the jury will frequently determine how much of the accident was intentionally caused. When compared to conventional negligence, when a person's act may have been unintentional, this sort of negligence is frequently handled differently. In the majority of the states, this is considered the most serious type of negligence. In a profession like medicine, actions of carelessness by medical personnel frequently fall into this category. An example of gross misconduct would be a home care nurse who neglected to feed and water a patient for several days. The majority of jurisdictions specify severe legal repercussions in cases of flagrant wrongdoing. It is presumptuous that the defendant intentionally fails to exercise due diligence, which results in significant damages. An allegation of gross misconduct is appropriate with such a complete lack of consideration for others. Let's discuss the next type of negligence, that is vicarious negligence. On occasion, the defendant may be held accountable for the activities of another person or animal. Example of this kind of behavior could include a child, a puppy, or a herd of cows. In certain situations, the pet owner, the child's parent, or guardians may be held accountable for vicarious negligence. In such a case, it is presumed that the person is indirectly accountable for the resulting losses or damages. Therefore, the only reasonable cause of action under the law in a dog bite case is to hold the dog's owners accountable for the harm and losses suffered. Now let's see an illustration of negligence. There are numerous examples of neglect that might aid in better comprehending these types of behaviors. For instance, if a medical professional administers an improper dose to a patient during therapy, the negative effects of the patient's health may be grounds for a negligence claim. Whether the activities were grave or ordinary negligence may need to be decided by the jury. Another situation is when a driver causes numerous collisions while inebriated. The motorists in this case can be held entirely accountable for the alleged gross carelessness. In another cases, reckless driving or speeding could cause harm or even death. Another example of negligence is when an engineer fails to ensure that a structure will be constructed to high standards. One of these problems can be the use of subpar materials. The engineer can be called to testify in court if such a structure collapses. Now let's see what is the difference between negligence and gross negligence. There is a chance of unintentional acts, behaviors, and omissions. When such conduct causes loss or damages, the extent of legal liability may be dependable in that context. When harm or losses are incurred due to disregard of the safety of others, gross carelessness may be present. In situation of common negligence, the perpetrator never intended to cause harm to anybody. It asserted, however, that the defendant's action in the case of severe negligence were intentional and more malign. With this, we come to the end of our today's lecture. Thank you.